Yeah. So I leave the time for the guests below and online. If you have any question about dispute or label dispute in Malaysia or Vietnam, yeah, or anything about labor.
The court system in common law countries and Vietnam countries. Later on, okay. I think my questions in the inquisitorial and the adversarial system is that you have two appeals, right? And both of them only on the question of law, right? Not on the facts. You don't have a retrial. So you when you already have the fact settled on the first case, on the first instance, that's it. You don't rehearsal of the fact in the appeal.
We do.
Oh, you do.
The
Okay.
first appeal is a rehearing.
Okay.
So, for example, if you take the High Court, after the High Court make a decision,
Yep.
the appeal to the Court of Appeal is by way of a rehearing. So it will look at both the facts, evidence,
Yes.
and the law. The second appeal from the Court of Appeal to the Federal Court is in a question of law.
Only a question of law.
Yeah, so you have at least one chance to have the facts reheard again.
Right.
But there are principles that apply, and mostly the appellate court will not interfere with any finding of fact made by the, say, the lower court,
Yep.
unless it's very wrong. Unless it's very
Okay.
wrong. So usually what we say differ and agree with the lower court, but
Yes.
you have a right to be reheard, just in case the first court got it completely wrong.
Yes. So in Vietnam, you have one rehearsal, right? Rehearing,
Yes.
The appeal. Then we have a cassation. In cassation, right, a revision of the law, and it applies in two situations. Number one is you apply the law completely wrong, and second is when there is a new fact that nobody know about, and with that fact disclosed, the outcome should be completely different. Would that be similarity in law countries?
We do have a system of review,
Right.
but again, it's not something that happens easily.
Yes.
So we have, for example, if I understand you rightly,
Right.
You have initially a first instance hearing,
Yes.
then you have an appeal.
Right.
Appeal is a hearing,
Right.
a question of law.
Right.
If you are unhappy with the question of law being heard,
Right.
you can apply for a review.
You
can apply for a review, but almost never granted, because we believe in certainty.
Right.
We must investors must know the law is certain.
Right.
And if something is wrong, the correction is made in another case. In this case,
Yes.
Otherwise, there can be review after review after review, and
Yes.
the case can go on forever.
Right.
Yeah.
Yes. Just you want to add any comments in relation to the proceeding? Yes. Hoặc là giám đốc thẩm, hoặc là yeah, the problem of Vietnam system that you can review and review many times, whereas in common countries you don't have that. Yes. And yeah, reconsider many times, and that I think the weakest point of Vietnam legal system is I must say is at court compared to other countries, and it creates unpredictability and also scary to the lawyers. That's why they offer arbitration, and that's why I think that's also the reason why arbitration in Vietnam, the Vietnam arbitration is quite popular, because people run away from the court and they find a place to escape to arbitration by making arbitration agreement. How successful they can escape is another issue, because then after the award, there might be an issue that the award might be set aside. It's not easy to set aside. I must say you can only set aside by procedural reason, not by merit, because court will not rehearse, will not rehear the case. But that's the topic. We'll come back at the arbitration case later on. What I learned from your presentation, Mr. Thiru, is that the court system is quite careful about how to apply the law, and it's also because that is fair decisions and it's up to interpretation, and also the role of the lawyers are very active in common law countries, and that explains why I have to say that law firms in common law countries is often bigger and more extensive than law firm in in civil country. I mean, name me a big law firm in France, for example, in Germany, for example, and they nowhere compared to England in terms of number, in terms of experience, and in terms of reputation. So, so I think that's something that makes the role of the lawyer strong. The thing that makes the role of the legal community strong in common law countries, and this is similar to most of similar common law countries, including Malaysia, Hong Kong, Singapore, and of course England, and also US, and also Canada and Australia. So then to the question is, okay, in certain area like loan agreements, they always say applicable law is English law, and they not accept using Vietnamese law, and we have to be familiar with English law. And maybe they say that you have to go to English court instead of going to arbitration. Let's say for loan agreement, they don't go to arbitration. Loan agreement, they usually go to court, English court. Why? Because arbitration is expensive. And the case in loan agreement is simple. You borrow me money, you don't pay, what you want to argue. Yeah. So I think that's the reason why they use court more often than arbitration. And we need to know about the process.
Dispute between the two parties outside the UK?
Very good question. Do you have like a long arm principle that you accept the jurisdiction, like Malaysian court accept a dispute between a Vietnamese and another Vietnamese, but they refer to a Malaysian court, like an FBI in Vietnam that invested by Malaysia, and they say, okay, if there is any problem happen, you go to English court.
We don't really have that relationship. I
Okay.
tend to be correct.
Right.
Can we do that? Can parties in Vietnam agree? I have a dispute, and I want to, yeah.
Hi everyone, I'm Siew. I'm wondering whether a different angle to answer that question might be that if you do obtain a judgment in Malaysia, whether you can actually enforce that in UK. Would that sort of answer your question as well?
No,
okay. Right. So we do.
Yeah.
Right. So in order for our local courts to have jurisdiction over the subject matter, there are certain criteria that you must satisfy. So even say, for example, that the contracting party is actually a UK entity,
right.
That will not confer jurisdiction on the Malaysian courts.
Yep.
So there are about 4. I think it's set out 4. Like for example, the subject matter, the contract relates to something that happens in Malaysia, or say the breach happened in Malaysia. There are some criteria which will then trigger the jurisdiction in Malaysia.
So you mean something like forum convenience? You have to show
yes.
that you have forum.
Correct. And material connection.
Material connection
yes.
with those countries to that. But I think like in your country, Mr. Bak, there's requirement to apply English law and maybe English court. And maybe your question is very important. That okay, is that material connection between English court with our case? If there is none, then probably that would not be acceptable over there, and then you run into something that nobody have any jurisdiction about the case. So that's important. And also the case of what you're talking about, the court system, that remind me about the case Đoàn Thị Hương in Malaysia. When she was arrested, she immediately go to court. And it's not like that in Vietnam. If someone is arrested, they would retain for months and months and months before appear to court. So I think there's many steps of appearing to court in common country, and seems to be that the court is the venue for solving a lot of dispute, not just the hearing itself.
So we call it access to justice.
Yeah.
You must give a sense of access to justice. Any dispute that you have, you can go to court.
Yeah.
So for example, it's an employment dispute. You saw just now.
Right.
If you are sacked and you're unhappy, you have 60 days. So within 60 days, you are in a system. If you miss the 60 days, you're no longer in the court system. You have to file a civil suit, which is not good for you. So if you are somebody who's been sacked and you think it's unfair, you have 60 days to make a representation, and a court process will start with that.
And they will do it immediately, or they
yes.
have to read the case, and they have to
immediately call you. I tell you how it works. It's very, very fast.
Yep.
In employment system, somebody gets sacked. More often than not, within 2 weeks, they will lodge a complaint.
Yep.
Within 2 weeks, they will be called in for conciliation. Can it be resolved?
Right.
If it cannot be resolved within 2 weeks to a month, it will be sent to the court. And once it goes to the court process will start, and
Yep.
the whole thing can end within 2 years.
Right. What if the court system is delayed? What is the sanction to the court who are in delay?
If the party who causes the delay, they say the employer,
Right.
when the award for compensation is given,
Yeah.
the court will take that into account.
Yes.
So if the employer days, lawyer sick,
Yeah.
lawyer overseas, lawyer playing ball, something
Right.
like that, and asks judgment, and the case doesn't go on, then when compensation is awarded, that will be taken into account. So everybody knows you must quickly finish the case.
Yep.
It cannot go on forever. So it's the same thing in our civil courts. If you file a claim, just now mention a civil claim, assuming parties,
Right.
courts actually must resolve the case within 2 years.
In Vietnam, it can be 3 years.
Yes,
If you
3
know,
years,
and
correct.
nobody punished court for being delayed.
Yes.
But
We
in
also have delays.
yes,
The principle is within 2 years.
the principle is within 2 years. And if the court, the judge is consistently late or not bring the case to justice, what will be the solution?
The judge won't be promoted.
Won't be promoted
Yeah,
to
it's the end, because he has to report. The judge
Yeah.
has to report
Yep.
how he handles his cases,
right.
and the bosses, superior judges will look at it.
Yes.
The judge is always adjourning case
Yeah.
because he doesn't want to hear case. Then action will be taken against the judge.
He'll be replaced. Yeah. We
He
will
may not
play.
be replaced, but he will not be promoted.
Yep.
So every judge wants to carry on with the case.
Yep.
Yes. So
Mm.
the system is very efficient in that way.
Thank you. Thank you. You have other questions in relation to the
Well, maybe we have a lot of presentation, very useful,
Okay.
waiting for. So maybe we will close this section here. And thank you so much for Stephen, Thiru, and Ms. Diệp.
yeah, thank you very much.
Thank you.
Thank you.